What are the crucial estate planning documents for your family? The critical estate planning documents are the following: a healthcare proxy, also known as a medical power of attorney, a financial power of attorney, if you own a pet power of attorney, and finally, a will and a trust. These legal documents are critical in order to empower you to take care of those you love and also allow others to take care of you. During this time, it's also important not that just you create the documents, but that they're easily accessible. Sadly, in my legal practice, I had found that people had done their legal documents. They did the right steps, they took the right action, they prepared their estate planning documents, but when the crisis hit, they weren't able to find them, or they had put them in a place where no one had the right to get to them. So in other words, you might have appointed someone to be your power of attorney, but because the document was in a safe deposit box, the power of attorney couldn't get the safe deposit box without the piece of paper. So it's a classic chicken and egg. That's one of the problems that Gentreo seeks to solve for people. We offer a Gentreo digital vault wherein people can store not only their estate planning documents, but other documents that are critical for information, such as health insurance information, home insurance information, additionally, information about doctors or a veterinarian if you own a pet. All of this information can be stored in your Gentreo digital vault, and you have the authority to be able to choose who you want to get what select information. So all this is very good in terms of the full package of what you need to fully protect your family. Right now, it's a challenging time, as we've already talked about with the COVID-19 pandemic. And even at the best of times, it's difficult to navigate the court system, even for a seasoned practitioner such as myself. But now, with social distancing and basically the courts are closed except for emergencies, it creates a much more difficult time. If, God forbid, you had a family member who suffered from COVID-19 and was in hospital and you didn't have a medical power of attorney, you would need to go to court to get authority, and it's usually called a guardianship, and in order to make medical decisions. Now, obviously, if you have someone who's sick, you don't want to be dealing with attorneys. You don't want to be dealing with court. You don't want that added emotional stress and financial strain. So that's why it's really important, especially for women, that we make sure all these documents are done, not only for ourselves, but for our loved ones, so that everyone is prepared in the event of an emergency. As we've learned from this COVID-19 pandemic, sadly, things can change in an instant, and it's really important not to panic, but to prepare. So one of the things that we can do while we're taking care of our loved ones is really taking the time to take care of ourselves. By preparing these documents, by taking the time to join Gentreo and go through the process of completing them, which, by the way, it's not hard. It's actually very easy. Our programming is such that we ask you very simple, straightforward questions, and you fill in your answers, and the complete document is printed. You're able to review it and make sure it says what you really want it to say. And so by doing this, you are really taking the critical steps you need to protect yourself and your loved ones. As you see on the PowerPoint, you don't want to procrastinate. You really want to move and get this done now. As much as this crisis has been a time of stress, it's also a time of opportunity. Now, because our pace of life as Americans, we're so busy all the time, again, especially as women who are managing everything. Things have slowed down a little bit. We're stuck at home. So take the opportunity to complete your documents. So we've mentioned them. Let's dive in deep about what each of these documents are. Beginning with a healthcare proxy, also known as a medical power of attorney or a power of attorney for healthcare. This is a document in which you designate someone and maybe name alternates to make healthcare decisions for you only in the event of you're not being able to. So in other words, you're still responsible for your healthcare decisions as long as you're able to. But if something would happen where you were incapacitated or maybe couldn't communicate your decisions, you have given the authority to someone you trust to make those decisions. It's very critical for all Americans over the age of 18 to do at least a health proxy and a power of attorney. Those two documents everyone should have, because it really is the ultimate protection while you are alive to make sure what you would want would happen. A Gentreo healthcare proxy has added questions in which you're able to designate what kind of care you would want. So I think most of us are familiar with the Terry Schiavo case, which was a very sad case. However, if you were able to clearly state what the care you wanted, it would have avoided that case. And that's what the Gentreo healthcare proxy enables you to do. You're able to say if you want life-sustaining treatment, if you want a do not resuscitate order, or if you don't want to make a decision, you just want to trust your healthcare proxy to make the decision, you can choose that too. But with all that, you are giving the authority for someone to make those decisions for you. In addition to the healthcare proxy, the other document that's very important is the financial power of attorney. A financial power of attorney, similar to the medical power of attorney, is a document in which you assign someone to be your power of attorney, your agent, in the event that you could no longer manage your money or your other assets. Again, at Gentreo, we allow you to make your choices about the time limits you want to set on this power of attorney, if you want to set time limits. And further, we offer you the opportunity to say what specific powers you want to grant your agent, also known as your attorney in fact. So this person is able to manage and make your financial decisions for you, again, when you're not able to. Obviously, both your healthcare proxy and power of attorney should be someone that you completely trust, someone who knows you, knows your values, and knows what you want. That's the person that you want to put in the power to make these decisions for you. We also suggest that you would pick alternates. The reason why, again, as COVID-19 has shown us, no one knows what the future brings. You might want to appoint your husband or your partner or your loved one as your first choice, but then what if something happens to him before you? You need someone else as a backup. If you don't appoint someone, what happens is the court oftentimes have to get involved, and that's a nightmare. The decision's no longer in your control. Sometimes it causes your loved ones to fight, and again, it causes added emotional stress. No one wants that. Now, the last will and testament. This is another estate planning document, but this document is only impacted when you die. This document allows you to appoint, most importantly, if you're a mom, to say who you want to be in charge of your minor children. You are giving the court guidance as to who you would trust, who you would want to raise your children. And, you know, again, as moms, as parents, we care so much about our children and we get so caught up in the day-to-day. It's really important that we take the time to cover all our bases in any eventuality. You don't want your family fighting over who's going to be in charge of raising your children if, God forbid, you should die before them. Avoid that problem by nominating someone to act as guardian. Additionally, and one thing that we probably all already know about what a will does, is that it enables you to say who you want to get all your stuff, your money, your property, your car, your special pearl necklace that your aunt gave you, all these things. And you can, when you go through the Gentreo process, you'll be asked those questions and you can put some thought into it and say where you want all your things to go. Also, you can donate to a charity. All of these things can be addressed, and it's really important. If you don't say what you want, your states have a default law as to who would get your stuff. And what I often see, and sadly, is that people have loving relationships with maybe one sibling and haven't talked to another in 20 years. But if you die without a will, both the sibling that you've been in touch with and really close to and the sibling you've had nothing to do with would share equally. Again, you want to avoid those problems. Now let's talk about the power of attorney for pet care. The power of attorney for pet care is a wonderful document that enables you to protect not only your pet, yourself, your pet sitter, and your veterinarian. It enables you to say what you would need. Now, during the COVID-19 pandemic and social distancing, we're not traveling. However, this document is very good for when we are able to travel. You're able to say who you want to take care of your pet, who your vet is. You can express your financial limitations on how much you could afford in an emergency for your pet. All of this gives great protection, and it enables you to empower the people who are caring for your pets to take care of them well. The final critical estate planning document is a living trust. A living trust is a way to think about it is that it's similar to a will, but it's actually created and funded while we're alive. This trust, so let's give an example. You own $100,000. When you create a living trust, you create a legal entity that you now transfer the ownership of your $100,000 into this living trust. This living trust document allows you, again, similar to a will, to indicate who you want to manage the trust, who's going to benefit from the trust, and its purposes during your lifetime. And usually what happens is when you pass away, the terms of the trust are set and the automatic distributions come from the trust. So in this case, a bank account that was owned by you individually, once you created the trust now owns it. You no longer own it. It's owned by the trust, and the trust uses that money per the terms of the trust that you've created to either benefit you or loved ones during your lifetime. And then when you pass away, you have set the terms in the trust about how you want the remaining money to be transferred. One of the things with a living trust is we always suggest that you also do a will. A will, a particular type of will called a pour-over will. This will has only one beneficiary, and the one beneficiary is the trust. And so that way, if there's anything in your life that you never transfer into the trust, for example, we talked about earlier, the pearl necklace. It's very hard to show that the pearl necklace was owned by the trust because it's a item of personal property. So what happens is when you do this type of will called a pour-over will, you say everything that you own will be, the only beneficiary is the trust. And that way there's no question about it and the trust can distribute it. So these are the critical estate planning documents. So we touched on this a little bit earlier. What happens if you did not do your estate planning document? Quite frankly, you have created a huge emotional burden and perhaps financial burden on your loved ones. These estate planning documents save time, money, and more importantly, preserve relationships. It's very challenging to get into court, again, under the best of circumstances. Now it's impossible. It's really a high burden that's there because the courts are only dealing with critical emergencies, which means people are in hospital and need someone to make medical care decisions for them. They don't have someone to do it. Other situations are pushed to the back burner, so there's no way to get a decision on that. The costs involved is high. my two co-founders, their family paid $10,000 for estate planning documents that we're offering at Gentreo for a much lower price point. We really encourage you to join Gentreo so that you're able to take the steps you need to preserve your family and protect your loved ones. These are critical estate planning documents, and our mission at Gentreo is to help all families be protected. We don't want money to be a barrier to being able to afford your legal rights. Without you taking the opportunity to document who you want to be in charge, it's natural. It's human nature. People are going to fight over it. People are going to say, oh, I should be in charge of the money, or I should be in charge of the health care. So you're really setting up conflict that you could avoid by taking the time to do your estate planning documents. So in terms of the Gentreo Family Vault, as I mentioned earlier, this is really a critical component of our product because it enables you, once you have completed and executed your estate planning documents, to store them in a secure location, not in a shoebox under your bed, not in a safe deposit box, but somewhere that you have granted access to your chosen people. So the beauty of Gentreo is that you can say, well, I want my daughter to have the information about the healthcare proxy, and perhaps I want my sister to have the information about the money. And so that you don't have to give all information to everyone, you can choose the information that you want to give. Another important factor with the Gentreo membership is that all these documents are not one and done. Life changes. We've all seen that. We get married, we have babies, people die, people get divorced. Things happen in our life and there are changes. And because of that, we want to adjust our estate plan. What's good today may not be good for us a year from now. I encourage everyone to review their estate planning documents at least once a year. So it's very important that the documents reflect what you want and have a current date on it. Additionally, all these documents need to have the proper witnessing and execution. Each state has its own requirements. At Gentreo, when you've completed your estate planning documents, you get a PDF which gives you instructions about what's needed to make it valid in your state. The other thing that we all recognize in this political climate is that laws change. There are always different situations. And again, what may be prudent for you to do today might change depending upon how the laws change in your state. Rest assured that Gentreo is always monitoring that and will keep you up to date on anything that you need to know about what's happening with estate planning in your state. So now that you've all had an opportunity to hear a little bit about all the pieces of estate planning, we'd welcome some questions, and I'd be happy to answer anything that's on your mind. Thank you again for taking the time to join me and learn about estate planning. So I see the question, if you have no children, is an estate plan needed? Yes. It doesn't matter if you don't have children. Everyone over the age of 18 should have an estate plan. And again, it's because it gives you the possibility of showing what you want to happen and how you want it to go. So even if you do not have children, you have other loved ones in your life that you want to benefit. And by having your will, you can say where you want that to go to. Do we have another question? Who is the best person to choose? That's a really good question. For each of these documents, there would be different factors about who would be the best person. So for example, on a medical issue, you might want to pick someone that you love, that you trust, that's well-versed in navigating the medical healthcare system. We all know it can be very challenging. Another thing to think about, similarly with the financial power of attorney, is there someone in your life who's very savvy about money and assets and can navigate all the legal and financial forms, which are sometimes very complicated. The bottom line on all of this, though, is that you really want to pick someone that you trust, someone that knows you and really knows your values and morals, because these are the people that you are tasking with making the most intimate decisions for you. You need to be able to trust them, and you need to be assured that when crisis happens, they will take care of you in the way that you would want. Another question is, if I die without a will, everything will go directly to my husband, right? Not necessarily. It depends upon the rules of your state. And every state is different. So if you want to make sure that your husband is your only beneficiary, you need to do a will. If you're one of the rare people who owns everything jointly with your husband, so everything, then it would automatically pass to your husband with the joint ownership. But most of us as married people have some things that we own separately. And in order to make sure that your spouse gets it, you really want to do your will. Another question is, what property can go into a living trust? Any property can go into a living trust. The challenge with a living trust is funding it, meaning creating the document on Gentreo, again, like creating our other documents, is easy. However, the next step can be challenging for people because you actually have to make the effort to fund it, meaning, as I gave the example of the bank account, you have to go to the bank and show the bank your trust document so that you can transfer ownership out of your name individually. That would be the same with the real estate deed and other items that have paper to show ownership. Sometimes people have extensive art collections, so there's papers indicating ownership. All of that would have to be transferred into a trust, but anything can go into the living trust. This is a question. Are any beneficiaries taxed on any money that is left to them? No. In America right now, there is an estate tax, but the federal estate tax exemption is very high. It's over $11 million per person. So in other words, you could gift up to $11 million and there would be no tax consequences. If you own over $11 million, there would be a tax consequence, but your beneficiaries wouldn't be paying that. Your estate would be paying it. So before the money's distributed, it would come out of that. Does a living trust avoid estate and probate taxes? So this is a good question. As I just said, most people do not experience estate tax consequences nowadays because of the huge, high federal estate tax exemption. If you live in Massachusetts, that's one of the worst states to die in that our state estate tax exemption is only $1 million. So if you own over $1 million in Massachusetts, there is a tax consequence. So taxes are something to consider in your estate planning. Some people choose to create a living trust in order to avoid those taxes and probate. Now, what is probate? Probate is the process in which probate is the word to describe the legal process in which a will is processed in the court system. That's all it means. In probate, there aren't any probate taxes, but there are probate legal fees. It costs $500 roughly in court fees to process the paperwork. And then there are the attendant costs of hiring an attorney to do it, of the missed time at work because of all the time you're spending in court to accomplish the goal of getting the will allowed. So a living trust, you can avoid probate that way. You can avoid those probate fees. And again, the estate taxes are covered because there's a transfer already into the trust. So this question is, what is usually needed to make it legal? I'm guessing that the person who wrote this is trying to ask about the execution requirements on the estate planning documents. Again, it depends upon each document and it depends upon the state. For a financial power of attorney, at a minimum, we recommend that you have a notary witness your signature. The reason for that is most financial institutions will not accept a power of attorney absent a notary. For example, in Massachusetts, it's not a legal requirement that your power of attorney be notarized. However, if you don't have it notarized and your power of attorney goes to the bank, it most likely won't be upheld, forcing that loved one to petition court to become your conservator. Again, you'll be in the boat that you've been trying to avoid by doing your estate planning properly. Other documents might require 2 witnesses and a notary, or 1 witness and a notary. Additionally, there might be specific limitations as to who can serve as a witness, because we want to be able to protect the people who are creating these documents, and we don't want them to be under any undue pressure or undue influence, or perhaps being further victimized if they're in a facility where they're taken care of. So there's limitations as to which caregivers can serve as witnesses. If they receive an IRA, there's tax consequences. And I'm wondering if they're saying, is there tax consequences? That would be set up by the terms of the IRA. The IRA passes separate from the will because usually the IRA or some insurance policies indicate a beneficiary, so that there's the estate planning documents aren't part of it, although it's certainly part of your prior decision that you want to take, prior decisions that you want to make. And depending upon how your IRA is set up and the terms of it, there may be tax consequences. The next question is, what is a living will? A living will is a document in which you indicate what kind of end-of-life care you would want in the eventuality of you were either in a permanent vegetative state or you were near death due to illness. This is a document in which you can specify, do you want artificial nutrition and hydration? Do you want life-sustaining treatments such as kidney dialysis, such as heart, cardiac? Do you want to be intubated or a ventilator or a respirator? And a living will enables you to indicate in writing what your wishes are. All states except for 3 in the United States allow someone to complete a living will. Massachusetts happens to be one of the states that does not allow for a living will. However, if you take the time to create one, this could be used as evidence if your case would ever end up in court. Additionally, so you all know, on this Gentreo webinar, Gentreo's healthcare proxy enables you to indicate what your wishes are. So not only is it a document in which you're nominating someone to make decisions for you, but it also enables you to create an advance directive, which is what a living will is, and say specifically what type of care that you would want. Finally, the Gentreo healthcare proxy also offers you an opportunity to write in specifically what care you would want and what care you wouldn't. So it really is a global document that enables you to fully control your healthcare choices. The next question is, if my maiden name is on estate planning documents and I change to my married name, will that be a problem? Do the names have to match? So no. in terms of legally probating it or presenting it. What ends up happening is, so for example, I mean, Connolly, if I had power of attorney that said Mary Kate Connolly appoints Catherine Connolly to be my power of attorney, and now I get married, and it's now D'Souza, Mary Kate Connolly's power of attorney in favor of Catherine would stand. However, one of the things that you might want to think about now that you're married is Catherine still your choice, or is your husband your choice? That's what the issue is in terms of your maiden name compared to your married name. Your life circumstances have changed, which probably indicate that your estate planning documents should change too. Now, if you've done a will under your married name and you pass away, again, the fact that it's under your maiden name wouldn't be a problem. The probate pleadings would be completed saying your name, also known as your married name. But the implications, again, of your will, you probably don't want because you're now in a different boat than you were before when you completed your estate planning documents. You probably want to adjust them to accommodate the change in your life with your spouse. What is usually needed to make it legal? I think I already addressed that one in terms of what's necessary to execute it. One of the things I didn't say when we spoke about this is now during COVID-19 and the pandemic, it's challenging to get it notarized. So some states have created emergency orders allowing for video notary. These are temporary orders, but they're giving an opportunity for people to create and have valid estate planning documents during the COVID-19 crisis. Well, thank you all so much for joining us today. It doesn't appear there are any more questions, so I'm going to sign off. I hope you take the time to join Gentreo and discover for yourself how we can help you protect your loved ones and all those things that are important to you. If you have further questions or you think about something later, please feel free to email us. Thank you.